A very good evening to all of you. Hello and welcome, guys. My name is KP Singh, and I welcome one and all to the 28th episode of Weekly Law Scoop. If you guys can see the screen and if the audio is fine, please write down yes in the comment section and ask your friends to join quickly. Welcome Aryan, welcome Arya, hello Chirag, welcome Ishan. Chale guys. Hello Lavanya, welcome Sashank. Chale guys. Okay, I'm Chief Mentor with IMS Get Set Law. I'm running IMS Jodhpur Center. I did my law from National Law School Punjab and Masters from Law School Kolkata. I'm pursuing my PhD in the field of international law. In order to select the best quality for this video, kindly click on the Settings tab on the bottom right hand corner of your screen and pick the best option available based on the device that you're using right now. Well, couple of announcements. IMS is conducting All India National Scholarship Test on this coming Sunday, 20th of March, and Get Set Law is bringing you an opportunity to avail up to 50% scholarship on all IMS Get Set Law programs, including test series. So if you have friends who haven't started preparing for law school, you can forward this message to those. And if you're watching this video and you haven't decided about joining an institute, do attempt this test. Check your mettle, just find out where do you stand right now vis-a-vis other competitors. If you're still double-minded, if you don't know whether to go for law, we are conducting a workshop tomorrow at 10:30 a.m. In order to register for this workshop, you can find the registration link in the chat section. So I have pinned these two messages at the top of your chat box. Just go through, click on the link, fill up the details if you are interested, or forward it to someone who might be. So let's start today's news bulletin with some positive news. CLAT got postponed. Most of you must know about it already. So, okay, we know, sir. Theek hai, chale, great. Will this be a CLAT pattern? No, Shaurya, this will be related to different law exams. Some questions will be based exactly on CLAT, some based on ALET, some based on some other law entrance exam. Okay, so CLAT committee has come up with a new notification this 14th of March. They have extended the application deadline to 9th May and now exam will be conducted on 19th of June. So a lot of time. Well, so जितने लोगों के board exam से उन लोगों ने राहत की सांस ली होगी. Good news for most of you. Similarly, ALET also decided to postpone its exam. Earlier it was supposed to happen on 1st of May. Now ALET will be conducted on 26th of June. So application deadline got extended to 25th May. Aryan says it's not good news. So Aryan might be a repeat taker. That means you don't have board exam related problems. Okay. ठीक है, चलिए. So another news is that Maharashtra Law CET also came up with a notification. They have announced their dates, but you have to take it with a pinch of salt. Exam is on 17th and 18th May for 5 law aspirants, and 7th and 8th June for 3 law aspirants. Application deadline for the same is 7th April and 12th April respectively. So MSCET का एग्जाम डेट संडे को भी नहीं है. आई थिंक इट्स ट्यूसडे एंड वेडनेसडे. सो वीकडेज पे है. मैनी पीपल विल फाइंड इट डिफिकल्ट टू अटेम्प्ट MSCET दिस ईयर, स्पेशली स्टूडेंट्स फ्रॉम CBSE schools. So there is a very high probability that they will postpone it, but as we are not in the business of astrology, we will presume it to be the final notification and we should start preparing accordingly. So fill up the form if you haven't already. IMS will also come up with a detailed form filling guidance video shortly. You can go through that video and then start filling up your application form. So Aryan says, I have an exam on 17th. I know, Aryan, many students are sailing in the same boat. So therefore I am saying that there's a very high probability that these guys will postpone this exam. MSCET in any case postpones this exam every year by couple of dates. So इनके जितने भी notification आते हैं, देखिए लिखा हुआ है, it's tentative schedule for higher education exams. So it will always remain tentative. Don't worry. let's move on. Okay, so today we are not going to pick up many news items, rather we will pick up a few and we'll try to go into the details related to those issues. First one is an update on what we discussed in the previous episode. Ukraine had approached International Court of Justice against Russian Federation. We discussed the major bone of contention between two. Ukraine's contention or argument was that it is a dispute relating to interpretation, application and fulfillment of the 1948 Convention on the Prevention and Punishment of Crime of Genocide, also known as the Genocide Convention of 1948. Ukraine had argued that Russia falsely claimed that genocide had occurred in Luhansk and Donetsk or Donbas areas, Donbas region of Ukraine, and therefore they are intervening, Russia was intervening to secure, safeguard and protect the ethnic Russian people in the Ukrainian lands. So they launched a special military operation against Ukraine, and Ukraine is alleging that there was no such genocide taking place. Rather, it is Russia on the other hand who is conducting genocide or war crimes in Ukraine right now. So, actus reus or the guilty act of genocide under Article 2 has been conducted by Russian Federation and hence this case. Genocide Convention is an international treaty signed between 150 plus countries. It was adopted on 9 December 1948 and came into force on 12 January 1951. Russia and Ukraine both are parties to this convention. So though ICJ, International Court of Justice, usually doesn't take suo motu matters, it can only take up matters when they are submitted to it by the contesting parties. But there is an exception to the rule which is called contentious jurisdiction. What is contentious jurisdiction? When only one party approaches the ICJ. In this particular matter, Ukraine is claiming that ICJ has jurisdiction because of Article 36 para 1 of the ICJ statute and Article 9 of the Genocide Convention. Genocide Convention Article 9 says if there is any dispute related to any provision mentioned in this convention between the signing and ratifying parties, that means member states, then the matter shall be submitted to the International Court of Justice. Article 36 of the ICJ statutes on the other hand says that if two parties are party to a particular convention which requires them to submit dispute before ICJ, then even one party, any party, that means even one party can bring that dispute before ICJ. So this is what is happening here. Ukraine approached the ICJ using Genocide Convention and Article 36 of the ICJ statute. So what happened at ICJ? Russia decided to abstain. Russia decided to not participate in the entire proceeding. President of ICJ, Justice John Donohue, stated that Russian ambassador Alexander Shulgin wrote a letter in which he indicated that Russian government will not participate in the proceedings. In ICJ, there are 15 judges and we have one Indian judge in the list. His name is Justice Dalveer Bhandari. So right now he is serving his second term. So I just need to go through the chat box. There's a lot happening there. Okay, people are discussing their own entrance exams. Christ University. Okay. It's not a good news. Arin says, I have seen the slide. Yes, it is continuation of what we discussed in the previous episode and we are going to take it forward from there. So in the last episode we discussed that there was a dispute regarding jurisdiction. ICJ gave opportunity to Russian Federation to come up with their representation. Russia decided to abstain. They said we will not participate, but they did respond to what is happening in ICJ by writing a letter to the Security Council. So they have given their own arguments, their side of the story to the Security Council, but not to the ICJ. Okay. So it is Russia's contention that ICJ lacks, International Court of Justice lacks jurisdiction in this particular case. Okay, so at that point of time, Judge John Donohue had stated that ICJ will come up with provisional measures or provisional orders. And now this is what has developed. So this 16th of March, ICJ came up with its verdict. Judgment was delivered by 13:2 ratio. That means majority, 13 judges were supporting what was decided. Only 2 people voted against it. So if I ask you to guess the nationality of these 2 judges, so there are 15 judges, all 15 are from different countries. President John E. Donohue is from USA. So president का vote किधर गया होगा, for or against? Obviously for. Okay. Vice president is a Russian guy. So the Russian guy voted against these provisional measures, and they got another judge in their support, the Chinese representative. Okay. So what are these provisional measures? There are 2. Basically, first one, ICJ has ordered Russia to immediately suspend its military operation, which they started on 24th of Feb 2022. Secondly, they have also directed Russia to ensure that any irregular units, militias, mercenaries, or individuals or organizations under its effective control shall take no steps in furtherance of Russia's military operation. So many times countries stop sending their regular troops, but they will continue their operation using irregular troops. So this is what Pakistan does to India. They keep on sending their best of the lot, Jaish-e-Mohammed and Lashkar-e-Taiba kind of Sasti Jaan volunteers to die in Kashmir. Okay. India voted in favor. Yes. So not India, Justice Dalbir Bhandari. Why am I saying not India but Justice Dalbir Bhandari? Because Indian stand on this issue has been that of neutrality. We have abstained on all 3 occasions, whether it was in Security Council or General Assembly. We have not voted against Russia. We have not voted in favor of Ukraine. We have always abstained in these scenarios. It was an Indian judge who supported the majority while delivering provisional measures against Russia. Okay. So it was further argued that in order the order on these provisional measures is binding in nature, and they are using Article 41 for that. So what is Article 41 of ICJ statute? I will show you the text. It says, the court shall have the power to indicate, if it considers the circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party. Now, there are a couple of questions that should pop up in the mind of scholars. पहला है, यहाँ लिखा है, the court has power to indicate. What does indicate mean? Indicate basically means suggest, इशारा करना. So if court is only suggesting or recommending, how is it binding in nature? So this issue has been debated on multiple occasions, whether orders issued under Article 41 are mandatory, are binding or not, or these are just guidelines. Okay. So in various judgments, ICJ has concluded that though word indicate has been mentioned here, but it should be considered as something mandatory. So it is not an option to pick and choose. If you are party to a dispute and if ICJ has decided in contentious matters, contentious jurisdiction, then there is no appeal and the order is binding. So what if a party to the suit says that I don't want to follow what you have decided, I don't agree? Then the petitioner or the winning side can go to the United Nations Security Council in order to get it implemented. But as we discussed in the previous episode, that would be difficult for Ukraine. Why? Because Russia is a permanent member of UN Security Council. Any proposal, any application which is put forth at UNSC will be vetoed by Russian Federation. Okay, so what happened at ICJ? It was Dalbir Bhandari's dilemma that we are talking about. There are 15 judges, 13 voted in favor and only 2 voted against these provisional measures. Justice Dalbir Bhandari was in favor of the verdict, whereas Vice President of ICJ, Judge Kirill Gavrejian and Judge Sue Hankin, Russia and China respectively, voted against it. Okay, so how are these judges elected? There are 15 judges and they are elected by the UN General Assembly and United Nations Security Council. Both these assemblies will be voting at the same time but separately in different chambers. Once appointed, a judge will remain in service for 9 years and 1/3 judges will retire every 3 years. So 5 judges will retire after every 3 years, new 5 judges will replace them. Justice Bhandari is serving his second term. For the first time he was elected in 2012 and then he got re-elected in 2018. Okay, so what we need to note down or what is attracting or making headlines is this, that all these judges except India and Uganda voted or decided in consonance with their country's own stand regarding this dispute. Only exceptions are India and Uganda. So, क्या होना चाहिए? Should Justice Dalveer Bhandari ने इंडियन गवर्नमेंट के स्टैंड को तो नहीं माना. So American guy was doing what American stand is on this issue. French representative was also following the French government's stand on this issue. Russian guy was supporting his own country. Chinese, as usual, were taking advantage of the situation. Right now, they are supporting China. But Indian judge took the moral high ground. India and Uganda were the only two who gave verdict in favor of Ukraine this time. But Indian government has abstained at 3 different occasions. So my question is, should he go to Pakistan? Shall we declare Justice Dalveer Bhandari a traitor? What is happening in the chat box? ICJ will go to UNSC, but Russia is there to veto it. Yes, Ali, that's correct. It would be funny if Russia is removed from the permanent seat and replaced by Ukraine. Aryan, that would be really difficult. Why? Because even a proposal to remove a country will be vetoed by Russia. Okay. Chaliye. So obviously answer is no. He is a judge. He is not Indian diplomat. So there's a difference. If Indian diplomat or Indian representative is doing something against Indian government, we can say that this person is violating his duties. But as a judge, you need to rise above your affiliations and you need to judge, you need to decide a case based on its own merits. So though the judges of ICJ are nominated by the countries, but they are expected to exercise their judicial opinions independently. So let's say if there is a matter before the Indian Supreme Court, a corruption case against the current government in power, do you want the judges to decide impartially, or shall they favor the government because after all they are also government servants? ये भी तो सरकारी कर्मचारी हैं. Okay. So we expect judges to deliver judgment impartially without any bias. Correct. Chaliye, so though they are nominated by countries, Indian government was fighting tooth and nail to get this guy elected to ICJ. Why? Because at that point of time, 2018, Kulbhushan Jadhav's matter was about to be listed. So at the last moment, we nominated Justice Dalveer Bhandari's name for re-election. There was a British representative contesting against him. At UNSC, United Nations Security Council, British representative won the vote, but in UN General Assembly, we won overwhelmingly. That means it was more than 4/5 majority in our favor. So later on, British representative withdrew his nomination and Justice Dalveer Bhandari's path became clear. Okay, so yes. Okay, chaliye, let's move on. A lot of opinions being shared. Judges are supposed to judge impartially. I'm not saying that they are superhumans or they are immune from all sort of biases, but as much as possible, judges shall discard the society. They are above the society. Chaliye, let's move on. So will Russia buzz? Again, my answer is no. This time they have come up with another argument. They are saying that there is no jurisdiction of ICJ. Their argument is quite simple. If you go through the letter submitted by ICJ, letter submitted by Russia to the Security Council, it says that we have not invaded Ukraine because of any activity related to genocide. That means we are not using provisions or articles of Genocide Convention 1948 in order to invade Ukraine. Rather, we are the victim side here. We got invaded by Ukrainian militias, also called Maidan. There's a famous Maidan documentary. You guys, if you have time, you can go through that. And these are a couple of brigades of Ukrainian neo-Nazi parties. So, by the way, Ukraine is the only country in the world जिसने neo-Nazis को army में जगह दिया है. So, they have created a separate regiment which is called Azov regiment, and these guys are openly neo-Nazis. So, Putin is not absolutely wrong in saying that Ukraine is supporting far-right groups. Anyways, chaliye, so Russian claim is that we are invoking Article 51 of UN Charter. What is Article 51? It talks about self-defense. So, if a country gets invaded, they have all the right to retaliate. They have all the right to use reprisal as a measure. What is reprisal? Reprisal means when a country behaves in a hostile manner in order to retaliate against the hostile act of another country using unlawful means. तो अगर इंडिया पाकिस्तान की टर्म्स अच्छे नहीं हैं and we stop talking or we stop negotiation, it is called retortion. But if we do a surgical strike, it is called reprisal. So right now Russia claims that we are doing reprisal against Ukraine. Okay. Chaliye, let's move on. Another controversy which is occupying primetime TV debate is hijab row or Resham versus State of Karnataka. Karnataka High Court has delivered a verdict and petitioners have decided to go for an appeal. So petitioners have approached the Supreme Court and whatever the Supreme Court decides, we will discuss it in future episodes. But right now we will try to declutter all the controversy and arguments surrounding the hijab row, and I will take you through the judgment of Resham versus State of Karnataka. So facts of the matter, this controversy erupted when a few Muslim girls at government PU college were denied entry for wearing headscarf. They contended that wearing hijab is part of their religious and cultural practice. Petitioner also challenged a government order dated Feb 5th. So in the month of January, sardi ka mausam tha, a few girls in this particular PU college started wearing headscarves, and later on another group from the same school started wearing saffron scarves, and this created two groups in the school, and both were adamant that we will put on what we like. Then school had to interfere, and school said that nobody will be allowed to wear anything other than uniform. And matter got a lot of support from other student unions across the city and across the state. So this became a statewide controversy with political groups trying to take active participation or active involvement in what was happening at government PU college. So government had to come in. Government came up with a declaration. It's a government order dated 5th Feb in which they clarified that it is the College Development Committee which has the power to determine what a person is allowed to wear and what they are not allowed to wear in the school premise. So these girls who were denied entry into the PG college, they went to the court claiming that this decision and the government order are violative of their fundamental rights. Sujit, well, thank you Sujit for writing that down and taking out time for that. Chaliye, let's move on. So this matter was put before the bench of Justice Krishna Dikshit. He said that the crux of the matter is that whether wearing a hijab is part of essential religious practice in Islam or not. And because this issue has been discussed in various Supreme Court and High Court verdicts in the past, it would be better if the matter is dealt by a larger bench. So I hope you guys know how many types of benches are there. When we say a single bench, that means there was only one judge. If we say a division bench, how many judges would be there in a division bench? How many judges are there in a division bench? Shashank is the first one to answer, and answer is correct. In a division bench, you will find two judges. It is also called a double bench. Charu, that's incorrect. Correct answer is 2. There are 2 judges in a division bench. Then larger than that, we have a full bench. So this matter was referred to a full bench. How many judges are there in a full bench? How many judges are there in a full bench? So a full bench comprises of 3 judges. That's correct, Shashank. Okay. Lavanya, that's incorrect. Trickiest, that's incorrect. Ali, that's correct. There are 3 judges in a full bench. And if there is a matter related to the interpretation of a constitutional provision, then we go for a constitutional bench. How many judges are there in a constitutional bench? How many judges are there in a constitutional bench? 55. Ultimate horizon. 5 is the right incomplete answer, but correct answer. Right answer is 5 or more in odd numbers. 5 or more in odd numbers. So full bench se upar you will always find judges in odd numbers. So 5, then 7, then 9, then 11. Largest bench in Indian history. How many judges were there? The case was titled Keshwananda Bharti. How many judges were there in the Keshwananda Bharti verdict? 13, yes. So even that was a constitutional bench. Charu, 11 is incorrect. Golaknath was a 11 judge bench judgment. So Keshwananda Bharti, there were 13 judges. No, not 33, 13. Okay. So if we want to overrule Keshwananda Bharti, we will need to constitute even larger bench. Then we will require at least 15 judges. Okay. How many judges are there in the Supreme Court? What is the total strength right now? Achha, what is the total capacity of the Supreme Court? Forget about the strength part because that will keep on changing. What is the total capacity or total? How many judges can be there? Your options are 30, 31, 33, 34. 30, 31, 33 or 34. Okay, Shaurya, that's correct. Aryan, that's even better. Arya, that's correct. Correct answer is 33 plus 1. So we say plus 1 for the Chief Justice of India. Who is the current Chief Justice of India? Another follow-up question. Before we move on to Resham versus State of Karnataka. So 33 plus 1, 34 judges can be there at our apex court as of now. Justice N.V. Ramana is the current Chief Justice of India. That's correct. Malvika, that's right. Chaliye, moving on. Okay. So Karnataka High Court full bench comprising of Chief Justice Rituraj Avasthi, Justice Krishna Dikshit, the guy who referred this matter to a larger bench, and Justice J.M. Kazi held that the prescription of school uniform by the state is a reasonable restriction and the students' right under Article 25 is not getting violated. And therefore, government order issued by the Karnataka government dated 5th Feb is also not violative of fundamental rights. Court dismissed the petitions filed by students and government order allowing colleges to determine uniform was upheld. So my question to all of you would be, do you support this verdict? क्या लगता है आपको? Hijab row. Do you support this verdict? Yes or no? Simple yes or no. जल्दी से. Okay. Yes. He who can't argue from both sides is no lawyer. आपको दोनों तरफ से बोलना आना चाहिए, but right now let's see. Shaurya says no, Lavanya says yes, Aryan says yes, Arya says yes, Trikyas says yes, Charu says no. चलिए, so all those of you who are saying yes, can you at least tell me which one of these is a hijab? आपके सामने 4 ऑप्शन है स्क्रीन पे, A, B, C, D. You can pick and tell me which one is a hijab. We are trying to understand the hijab controversy. Okay, trickiest will go for C, Aryan will go for C, Arya Bharti will go for A, another one for C. Okay, Charu says that's a funny bonus question. No, it's not funny. It is interesting to know that people have made up their mind that whether hijab is right or wrong, but are they able to identify what is a hijab? Lavanya says C, Prachi says C, Sashank will go with C. Oopsie. Correct answer for this one is option A. So, option D is a burqa, C is a niqab. Option A is a hijab. So, what is a hijab basically? Hijab is nothing but a headscarf. So, अभी सर्दियों का टाइम था, मफलर लगा के गए स्कूल आप? Any Himesh Reshmiya fan putting on a cap, even that's a hijab. So, hijab is a headgear, it's not a burqa. It's a headscarf. So, now, chaliye, so basically, if you are against hijab, you should at least know what is hijab. I think that's a fair point to make. So, these were the questions laid down by the by the High Court. There were 3 questions. First question, whether wearing hijab is essential religious practice in Islamic faith and therefore protected under Article 25. What do you think would be the answer for this one? If you guys are following news, you should know the answer. चलिए. Whether wearing hijab is essential religious practice in Islamic faith protected under Article 25. Article 25 gives us right to practice, profess and propagate religion. Court says no, it is not essential religious practice. Okay. Chaliye, next question framed by court. Whether prescription of school uniform is violative of rights. क्या schools को uniform decide करने का right होना चाहिए? And will that violate your fundamental right? We are not discussing Quran or any religious scripture right now. Just stick to the judgment delivered by the court. You are students of law, not philosophy or theology. Whether prescription of school uniform is violative of rights. तो अगर स्कूल आपको यूनिफॉर्म बताता है तो क्या वो फंडामेंटल राइट्स का वायलेशन है? No. So, if you have answered no for the first 2 questions, it would be easy to answer the third one. Whether government order of 5th, apart from being incompetent and manifestly arbitrary, violates Article 14 and 15. What is Article 14? Article 14 says right to equality. Equality before law and equal protection of law. What is Article 15? Article 15 protects against discrimination. There shall be no discrimination on the basis of race, color, caste, creed, place of birth, gender and other grounds. Okay, Shaurya is trying to put up an argument. Shaurya, I will try to answer all these questions today. Last time when I was discussing, I thought discussion went sideways. So today I thought we'll try to sort out the controversy, and therefore the title is Decluttering the Hijab Row. So based on what you have answered so far, our correct answer for the third question would again be no. So there are many questions जो आपके दिमाग में आ रहे हैं. So let's try to get into dive deeper into those questions. So has the High Court banned the hijab in Karnataka? Yes or no? Has the Karnataka High Court banned hijab in Karnataka? Yes or no? Yes, no, yes. No, not at all. Okay. Well, guys, answer is no. So, Muslims are allowed to wear whatever they want to wear, not just in Karnataka, but anywhere in a country. So, people of all religion, whether men or women, they are allowed to wear their religious symbols or clothing as per their choice. So, there is no restriction on hijab per se. Okay. चलिए, so उसके ऊपर से थोड़ा डस्ट हटा. तो नेक्स्ट क्वेश्चन. So has the High Court banned hijab in schools? Somebody just commented something on those lines. Aryan says just banned from wearing in educational institutions. So has the High Court banned the hijab in schools? Okay, trickiest says yes. Aryan says yes. Prachi says yes. Shaurya says yes. Shashank says yes. Again, everybody got it wrong. Malvika, that's the correct answer. Harshvi, that's the correct answer. No. So, High Court has merely given schools the right to decide their own uniform. तो अब ये decision किसके पास है कि स्कूल का यूनिफॉर्म क्या होगा? Obviously, स्कूल के पास. So, schools will get to decide their own uniform, and आई थिंक दैट हैज बिन द केस सिंस टाइम इमेमोरियल, और एटलीस्ट जब से हम पढ़ रहे हैं हमारे स्कूल से डिसाइड करते हैं, हम तो डिसाइड नहीं करते ना. Let's say if bell bottom is in nowadays and I want to put on bell bottom and go to my school, will they allow it? No. So no, High Court has merely given schools the right to choose their uniform, and there are minority educational institutions in our country. So there are madrasas, there are various schools being run by Muslim religious societies. There are Saint Soldier schools being run by Sikh community. There are Mahavir Vidyalayas run by Jain communities. We have convent schools across India run by the Christian community, and they also get to decide their own uniform. And if you have ever come across any madrasa, you will see that headscarf is a mandatory part of uniform at those schools. Okay. Chaliye, let's move on. Next question. So how can the government or the court tell somebody what to wear? Is this not unconstitutional? ये तो हद ही होगी. सरकार बताएगी क्या, या कोर्ट बताएगा क्या पहनना है क्या नहीं पहनना है? How can the government or the court tell us what to wear? Is this not unconstitutional? I think it should be, and yes it is. So इसीलिए कोर्ट नहीं बता रहा है. So this is the reason neither the government or the court is telling people what to wear. What they are doing is simply allowing schools to decide their own uniform. And the word uniform itself means that there is no choice, people have to be uniform. Okay. But is it not the choice of a girl or her parents in case of minors whether to wear the hijab? Another question. Let's see how you answer this time. Isn't it choice of the girl to decide? My life, my choice. Government can put restrictions on reasonable grounds based on public order and morality. Ali says, but this didn't disturb the public order, so the court didn't enter the matter. ठीक है, चलिए. Yes, it's her choice. Charu says it's her choice. That's correct. But there is also parents' pressure, Aryan added. Okay, guys. Well, people have right to choose what they want to wear, but not everywhere. So, for example, let's say if you join a particular unit in Indian Army, you have to put on the uniform. If you are working for police department, you will have to put on the uniform prescribed for police department in a country. If you are studying at a school, then school has the right to decide the uniform. And the word uniform, as I said, itself means that students don't get to choose. But outside the school, you can wear whatever you want to wear. Okay. So, in that case, are we admitting that school is taking away choice from the students? Answer is yes. But this is not being done vindictively or selectively against one particular community or group or religion. Rather, uniform can be of any form. So, let's say agar mere school mein, I am from St. Anselm Sajmer, which is mother branch of all your St. Paul's and St. Anselms across India. We used to wear navy blue pants. I used to hate that color like anything. So, one day I decided that I will put on, let's say, my denims and go to that college. Will they allow me? Do you think they would have allowed? Nah. हमारी स्कूल में it was only allowed if it was your birthday. On that day आप रंग बिरंगे बच्चे बन के जा सकते हैं. Otherwise, you have to put on whatever ridiculous uniform your school has prescribed. चलिए, so but there is a larger question here. Uniform होनी ही क्यों चाहिए? If that is something that is worrying you, then obviously that's a bigger debate. Why do we need to have uniforms? Our schools were created in order to produce, rather mass produce clerks for the English government. So अंग्रेजों के लिए clerks बनाने के लिए factories बनाए गए थे स्कूल के नाम पे. And that is the reason the kind of habits which they want to inculcate are suitable for a perfect clerk. So you should be punctual, you should not think out of the box, you should follow discipline. If there's a question which the teacher can't answer, he will simply scold you and ask you to shut up. So that way you will simply follow the orders without looking for creative solutions to the problem. So whether schools shall have uniform or not is a bigger question, and I think this wasn't even asked in this particular case, so we can also skip here. ठीक है, चलिए. So another okay, आगे बढ़ते हैं. चलिए, another question. अभी किसने कमेंट भी किया था, but 6 wear turbans to school and nobody objects. Why not treat hijab the same way? Now, this is something that everybody should know, that under Indian law, people can get exemptions for essential religious practices. So if it is your essential religious practice, you can get exemption for that. And this isn't just applied to school uniforms. Sikhs are also allowed to put on turban while riding a bike. So they are not expected to wear a helmet. There will be no challan for riding without helmet, right? So in this case, High Court simply decided that hijab is not an essential religious practice. But then who decides what is essential practice for someone's religion? ये कौन बताएगा? अरे कमेंट्स में क्या चल रहा है? Well, considering the Hindutva group, they will make in a full hate speech, and therefore this session is important, Shashank. Okay, चलिए. So who decides what is an essential religious practice for any religion? In our case, in our country, it is the court who gets to decide. And how do they decide? Not based on their whims and fancies. They will look into the religious texts, scriptures and practices of that particular faith, and then they will get to decide whether something is essential or not. And similar exercise was conducted even in order to find out whether hijab is essential or not. Okay, so it seems like a complicated and confusing matter to prove that something is essential practice to religion. Is the court being vindictive against Muslims? Again, answer is no. Rather, all religions in our country suffer because of this essential practice test. So it is, you can say, necessary evil or a blessing in disguise. इसके काफी benefits भी हैं और तो कुछ pitfalls भी हैं, shortcomings भी हैं. Rather, Hindu community has been the single largest victim of this essential practice test. Why? Because in Hinduism there is no central scripture or text. There is no consensus कि अच्छा एक ही book होना चाहिए या एक practice is the right, this way of practice is the right way of practice. There is so much of diversity within Hinduism that it becomes difficult for Hindus to prove anything to be essential to their faith. And that is the reason we have been reading about so many judgments year on year which regulate different aspects of Hindu religious practice. For example, eco-friendly Ganpati or cracker-free Diwali, or even one's court tried to determine how much milk can you pour on Shivling. Why? Because all these things were decided to be non-essential part or practice related to religion. Chale, so why is court getting involved in making decisions based on religious scripture? Well, I believe it shouldn't be court's job to interpret religious scripture. They are not the authority on this subject, but they have to. So school छोड़ दीजिए, they decide on every aspect related to religion, whether it is related to marriages, divorce, inheritance. Everything is based on interpretation of various religious texts with a dash of constitutional morality and test of essential religious practice. So any aspect related to religion, whenever court has to decide, they apply these three things. They will look at all your scriptures, your practices, your historical sources, then they will apply the essential religious practice test, and even if it appears to be an essential practice, then they will apply constitutional morality. So what is constitutional morality and what is doctrine of essentiality? Well, this doctrine came up in Shishur Mutt case in 1954. A 7-judge bench decided that religion covers all rituals and practices integral to a religion. Integral means inseparable, important. चलिए, I feel it is not the courts or Hindus against Muslims or vice versa, but some certain people against community and including victim minds and turning them into proxy wars. So that happens in every field. Ari, don't worry about it. So chaliye, what is doctrine of essentiality? Doctrine of essentiality was invented by a 7-judge bench in Shishur Mutt case 1954. Important fact for this year's exam. It was decided that religion will cover all rituals and practices which are integral to a religion. And therefore, the court decided to take it on itself the responsibility of determining what is essential, what is not. So, जैसे basic structured doctrine आया केशवानंद भारती के बाद और उसके बाद से courts regularly determine करते आ रहे हैं what all will be considered part of basic structure. Similarly, once this doctrine was invented, they kept on using it in order to determine what is essential, what is not. It is a contentious doctrine. Obviously, every time you touch upon subject of religion, there will be people protesting against it. But because of this doctrine, many good things have also been introduced in our system. I will give you examples for that. What is constitutional morality? It says that while applying laws or rules, regulations, or even statutes, we have to make sure that we are not just trying to implement the rule, but the soul of the constitution. So it specifies norms or conditions for institutions to survive, an expectation of behavior that will meet not just the text but the soul of the constitution. And it makes all the governing institutions and representatives accountable for achieving this. Chaliye, for example, decriminalizing homosexuality. Isn't it a step in right direction? Some of you might say no, but majority will now agree that yes, it was. I will give you a couple of more examples. Shri Venkatramana Devaru versus State of Mysore, case of 1958. Shri Venkatramana Devaru versus State of Mysore, 1958 judgment has Supreme Court decided that restriction of entry into temples for some sections of society is not an essential part of Hindu religion. Very important judgment. Based on this judgment, all the Hindu temples were thrown open for all sections of this society. Anybody could enter a Hindu temple and worship now. So, some sections of our society, like Harijans and Dalits, were not allowed to enter certain temples in some parts of our country. And because of this judgment, now they can. Ayodhya case. Question was whether offering namaz is an essential practice. Court said yes. But is offering namaz in the mosque an essential practice? To which court said no. So, offering namaz might be an essential practice, but it is not necessary to offer namaz in the mosque. Shabrimala case. There was a ban on women of a particular age group, anybody falling between 10 to 50 years, basically menstruating age. They were not allowed to go to Lord Ayyappa's shrine in Shabrimala, Kerala. So, this religious practice came into conflict with right to equality and was discriminatory against women of certain age. Court held that this centuries-old Hindu religious practice was unconstitutional and violative of Article 14. Okay, chaliye. So there have been many benefits of this. Like we struck down Section 377 of IPC. I hope you guys know what 377 dealt with. Section 377 IPC penalized homosexual behavior in a country, and because of that, it was a crime to be a homosexual in a country. So it was struck down using the doctrine of constitutional morality. It was given primacy over religious morality. If you go and meet religious orthodox people, they will still say that it's a sin, it is an abnormality and people shall be lynched or killed. But constitutional morality prevailed over religious morality and homosexuality was decriminalized in a country. It also ensured social justice during practice of right to freedom of religion. Women were given equal share in ancestral property using this same doctrine. It establishes the rule of law. That rule of law is of primary importance rather than rule of religion. So whenever there is a conflict between fundamental rights related to religion and related to equality, it is generally equality which prevails. And lastly, it also protects religion. This doctrine is protecting the essential practices of religion from interference of state. if anything can be declared to be an essential practice, then government is duty bound to protect it by making exceptions in different fields. Such is the case of Sikh turban in our country. So थोड़ा सा हैवी हो गया, हम इससे ज़्यादा इसमें नहीं जाएंगे. आई होप यू गाइज गॉट टू लर्न समथिंग न्यू. थोड़े से दिमाग के ढक्कन खुले होंगे. एंड नाउ यू विल नॉट डिबेट इन व्हाट्सएप ग्रुप्स विथ योर रिमोट चाचा ताऊज एंड अंकल्स एंड गेट इन टू हेट स्पीच. चलिए, so a quick reminder, we are conducting a national scholarship test tomorrow. You can ask your friends to join in and try their mettle. And there's a workshop for all those people who are not yet sure whether to pursue law or not. You can share it with your friends, and I will be conducting that workshop tomorrow, Sunday, 10:30 a.m. Thank you so much for watching. Don't forget to click on that like button which you see on your screen. It will not cost you anything, but that will give us enough appreciation to work for the next session. Thank you so much, guys. Okay, Ali says, please take lynching bill ASAP. Okay, we will. Once this live session ends, leave your comment on the video so that I can come back and see what all you want to cover me in future sessions. Your live chat will vanish the moment I click on end stream. Okay. Well, so keep लाइकिंग, शेयरिंग एंड सब्सक्राइबिंग. याद रखिए, शेयर करने से ज्ञान बढ़ता है और साथ में सब्सक्राइबर्स भी. थैंक यू सो मच गाइस. बाय.